Hereby call to order the combined meeting between the Connington County Commission and the Watertown City Council. I would like everyone to please rise for a prayer by Hank Rosso from the Midwest Bible Camp, followed by the Pledge of Allegiance. I would like to do the roll call for the city before I pass it off to Brenda Hanton, the head of the Connington County Commission. So, Kristen, would you please call the roll?
Okay. Bueller?
Here.
Danforth?
Here.
Holeen?
Here.
Paulson?
Here.
Shetty?
Here.
Tupper?
Here.
Vilhauer?
Here.
Thank you.
Quorum established. Take it away, Commissioner Hanton.
Thank you, Mayor Reed. Holeen, I would like to call the Board of the Connington County Commissioners to order September 7th, 2021 at 5:30. It looks like we have a quorum here, but I would look for them to have a motion and a second to approve the agenda.
Second.
Motion by Van Duzen, second by Gable. All in favor say aye. Aye. Opposed? That motion carries.
And the city now has to also establish, approve the agenda for tonight. So with that, the chair will entertain a motion to approve the agenda. Moved by Councilman Schutte, second by Councilman Bueller. All those in favor, please say aye. Aye. Any opposed? Motion carries. One quick note: I will pass the gavel off to Commissioner Hanton here in just a moment. What we are going to do tonight in this format for the combined meeting is we have business to do with the county. To start off, we are going to handle all county and joint jurisdiction with the county agenda items first. If you are here to testify about the city ordinances, we are not doing that until after the commission, the Coddington County Commission, leaves to respect their time. So if you are here to testify or for comments upon the city ordinances, you can wait until after the commission leaves. I also would ask you, if you are here and you do plan on testifying, there's a sign-up sheet over by the front, by the entrance, and I would ask you to sign in, please, so that we have a record of your name and who you are representing. With that said, thank you very much, and I will pass it off to Commissioner Hanton.
All right. Thank you, Mayor. The first item of business is to open the joint public hearing in front of both the Watertown City Council and Coddington County Commission regarding cannabis regulations. In the joint jurisdiction zoning area and in the rest of the unincorporated areas of the county, as the mayor noted, we will not be taking testimony on any ordinances regarding cannabis within city limits at that time. The city will take up that after we adjourn this meeting. Just like last time we met together, it makes sense to hear comments on the joint jurisdiction zoning amendment and the county zoning amendment and the county licensing ordinance at the same time. Council and board members, I'd ask that we allow all testimony from the public on these regulations inside and outside the city before we close the joint public hearings and discuss these ordinances amongst ourselves. Todd Kays is the Executive Director of First District and will help guide us through this meeting. He will give a brief description of what is within the ordinances and why we are meeting jointly, and then we will call on members of the public that wish to comment. Todd, would you start?
Thank you, Commissioner Hanton, City Council members, Board of County Commissioners. The First District also provides zoning services to the county, and Luke Muller is the county zoning officer, and we often act as a conduit between the city and the county. And so just a quick synopsis of what you're going to be hearing on the public hearing and acting on. As previously stated, we are going to be talking about the ordinances 75 and 77. That's the green unincorporated area of the county, and ordinances 76 and 21-35. 75, that's for the yellow area on the map. That's the area of the joint jurisdiction. Ordinances 2134 and 2136, that purple area, the city limits incorporated, will be a subsequent public hearing discussion afterwards. Ordinances 75, 76, and 77 are county-related ordinances. One is for the zoning regulations for the rural area. One is the licensing regulations for the rural area. And Ordinance 76 would be the county side of the joint jurisdiction ordinance, and 21-35 would be the city side of the joint jurisdiction. Both 76 and 21-35 are identical in nature as far as language and substance. It's just one is for the city and one is for the county. On the county side of the ledger, basically, Ordinance 75 and 77 deal with the amendments to the zoning regulations and the licensing process for which individuals who want to start a cannabis facility in the unincorporated area of the county. And bottom line for the county, briefly, there are 4 types of cannabis facilities contained in their zoning regulation and in their licensing regulations, dealing with dispensaries, cultivation facilities, manufacturing and testing facilities. In the green area of the map up there, Connington County Planning Commission has made recommendation to move forward with the zoning regulation, which stipulates only 1 dispensary would be allowed in that green area of the map in the unincorporated areas on commercial or industrial zone property. There would be no cultivation, manufacturing, or testing of those types of facilities located in the green area of the map. The licensing regulation, and I believe that's Ordinance 77, basically stipulates that, again, the county would have 1 dispensary in a commercial industrial zone area outside of city limits and outside the joint jurisdiction area, and that the hours of operation, I think, was Monday through Saturday.
It was 9.
I'm sorry.
Yeah.
Say it again.
It goes from 9 to 10.
9 to 9.
9 to 9.
9 to 9, Monday through Saturday. And then the county is also charging a $5,000 licensing fee for that dispensary license. Within the joint jurisdictional area, it's a real easy ordinance. Connington County and the city's joint jurisdiction ordinance has a codicil within it that stipulates if a use is not listed as a permitted or a conditional use within that specific joint jurisdictional area, it's not allowed. So the only ordinance amendment that's going to happen with the 2 respective city and county ordinances is that we are going to define medical dispensary, a medical cannabis manufacturing, a medical cannabis testing, and a medical cannabis growing facility or cultivation centers. So by listing them in their definitions and precluding them from the development in that yellow area, they would not be allowable uses. You wouldn't have the ability to ask for a permit to do that. So that is a very cursory review of the ordinances for the county to consider and the cities on the joint jurisdiction. Any
It was 8 to 9 any day of the week.
8 to 9 any day of the week, any day of the week, excuse me, for that 1 dispensary in the green area. Any questions of the commission before the chair? Okay.
All right. Did anyone from city staff have anything to add?
I don't believe so. Thank you.
Mr. Mayor, should I open up the public hearing on behalf of both boards?
Please do.
Okay. Consider the public hearings open on County Ordinance Number 75, an ordinance to amend Article 2 definitions, Section 3.05.01, permitted uses, C, Commercial District, Section 3.0601, permitted uses, I, Industrial District, and Article 5, supplemental regulations adopted by Ordinance 65 as amended of the zoning ordinance of Connington County, City Ordinance Number 21-35, and County Ordinance Number 76, Ordinances to amend Article 2 definitions of the joint zoning ordinance for Connington County and the City of Watertown, and County Ordinance Number 77, an ordinance establishing licensing provisions for cannabis establishments to the revised ordinances of Coddington County. Before speaking, please state your name and which jurisdiction your comments are intended to be in reference to. And lastly, in case you came in late, please remember this is not a hearing regarding the regulations of cannabis within the city limits of Watertown. That hearing will be held following the conclusion of this meeting, and I'll have to rule you out of order and ask you to return to your seat if you address those ordinances. We will also allow up to 3 minutes on these sorts of matters for people to state their comments. So with that, the public hearing is open. Is there anyone that would like to speak on that? Just come up to the mic, please. Is there anyone who would like to speak on the county ordinances? Is there anyone who would like to speak on the county ordinances? All right, I am not hearing any, so I will close the public hearing. So we have read the titles of both the city and the county's joint jurisdiction ordinances, and when we open the public hearing, so both of our second readings have already been addressed. To follow Robert's Rules of Order, before we have any board discussion, I would like to get a motion on the floor by each organization to address the joint jurisdiction area. County Commissioners, can I get a motion to approve ordinance number 76? Motion by Van Duzen, second by Waterman. All right. And then we have a motion and a second. So do we have any discussion? Okay.
At this time, the chair of the City Council will entertain a motion to approve ordinance number 21-35.
So moved.
Moved by Councilman Tupper, seconded by Councilman Vilhauer. All those, actually, any comments on that?
Don, why don't you just ask for chair comments for both of us?
Councilman Danforth.
I just want to make sure that I'm understanding this. Brenda or Todd, the unincorporated area would not be the municipality of Henry or Florence, correct?
No.
Do they make their own individual rules then?
They are having the opportunity to do that. They were given draft regulations. I know Henry is working on that right now. I'm not aware of the other communities taking this up.
Okay. Mayor, can I ask another question if I could? I'd like to understand, because I wasn't at any of your meetings, but what was the discussion and the means to which you arrived at a restricted number of dispensaries, as well as your discussion on the setting of the fees that are noted?
Madam Chair?
Yes.
Coddington County, like many other municipalities throughout the state within the planning district, is relying on a template ordinance that was developed by Matt Roby, myself, a gaggle of attorneys across the state, and South Dakota Public Assurance Alliance. And within that, the initial start was to start with what the state regulations are saying, that you have to have one. In discussions on the county side of the equation with the Sheriff's Department, and not wanting to see a raft of these types of establishments spread out, which would make it difficult for policing of that in the rural areas of the county. That was one of the principal reasons. Also, Connington County historically does not allow for a lot of commercial development outside of the joint jurisdictional area. I think we have maybe 3 locations outside the county. We don't promote a lot of commercial industrial development historically over the 50 years of zoning practice. So based upon that, Madam Chair, I did not attend the Planning Commission, but I think that's what Mr. Muller, the zoning officer, would have said at that time.
Yes. That is correct.
Any further questions, or Councilman Bueller?
Thank you, Mayor. Todd, just a point of clarity here in regards to the background information that we've got for the joint jurisdiction area. I believe the yellow portion of your map was a joint jurisdiction area that was established by the City Council and the county commissioners some years back. I'm going to guess, yeah, somewhere in that neck of the woods. It does say in the ordinance here that you have that it's a 3 mile. So I don't know if you want to change that to an established joint jurisdiction area per the city council and the county commissioners versus a 3 mile. That might be confusing. Thank you.
Point out that language for me, Bruce, we're at.
Yeah. Excuse me. It says the joint jurisdiction area encompasses a 3 mile area outside of the city limit boundary.
Yeah.
And it's in the background information for the ordinance.
Oh, okay. Luke would have wrote that. Duly noted.
Any follow-up, Councilman Bueller?
No, thank you, Mayor.
Councilman Vilhauer?
I've got one minor question. The hours of operation from what's proposed for the joint jurisdiction area don't quite mesh with what we're proposing within the city. And I realize we've got two different, jurisdictions here, but is there any concern on the part of my colleagues and my counterparts of the county as far as those hours not quite meshing?
Hours operation, there are not going to be any allowed in the joint jurisdiction, so that's just the county outside of the joint jurisdiction area.
Okay, so there's no concern on your part about a little bit different hours versus what the city might be proposing?
Madam Chair. Within the joint jurisdiction in that yellow area, there will be no medical marijuana facilities located whatsoever. And in the green area, presently there's about 3 locations, one up by Waverly, the Rooster Bar area out there, there's some a little bit past that, and out by Henry, there's a piece of commercially zoned property. So those would be the locations.
Okay.
Any further questions or comments from the council? Councilman Paulson?
Thank you, Mayor. I guess, how did you guys come up with not allowing testing, manufacturing, or cultivation?
Madam Chair.
At this time, that's just something that can be addressed down the road. We just felt we did not want to do that this time until we get more information as time goes, so.
Also, just on top of that, based upon recommendations from the Sheriff's Department, again, having to, where we would locate these things, and again, we don't have the history in Coddington County of rezoning property for commercial uses. I believe, Councilman Danforth, I don't think I answered your question regarding the fee. The fee originally, again, came out of the template document that was created by planners and attorneys. And in that template document, $5,000 was the starting point based upon the Department of Health preliminary rules at that time saying that the state would charge $5,000. And being consistent with that $5,000 fee, many of us felt that we should, it says it needs to be reasonable. Many of us felt that if the state's charging $5,000, the reasonable number would be for the localities to also charge $5,000. And so that's our basis, and then waiting to see what happened down the road. Is that correct?
Councilman Danforth?
I just want to make sure I understand our role here right now, because you're going to be looking at approving your ordinance language, which could be different than ultimately what the city's is. So are we going to be doing any voting on this, that we're going to be voting on the joint jurisdiction?
But there are no facilities, so there are no licenses in the area that there's no shared control over. The shared control between the city and the county would be in that yellow area. No locations can be allowed.
So the number of dispensaries and the fees they're a moot point. Okay?
Exactly.
So there's nothing else in the ordinances that we'll vote on that might be contrary. There shouldn't be anything there.
No, because we're not allowing it in the yellow area while you're allowing it in the purple.
Okay, so here's my other question. Are you going to be approving your ordinances tonight also? Will that be done before the city? Okay. What happens, and I'll just say, what if your fee is 5,000 and we vote something higher than that, something different than
Well, it
that?
depends on who you're asking. If I'm a developer or if I'm, what ends up happening is the market takes care of that situation. You also got to remember, in the county, there's only a few locations that you might be able to do that, so it's going to be very
No,
difficult.
but the fee, you're setting the fee.
Yes.
Okay, what I'm saying is, whatever fee you set could differ from what the city of Watertown
Yeah.
does.
Yeah.
And we're all okay with that.
Well,
Okay.
I mean, it could be Henry, it could be Wallace, it could be Florence. There could be no fees. I mean, right now, Wallace doesn't have zoning. If I'm looking for a place to land one of these things, I'm going to Wallace.
Mayor?
Yeah. Oh. City- I heard a voice out there. City Attorney Roby.
To just expand on Todd's point there, I think that's inevitably what's going to be happening across the state is there's going to be a patchwork of rules in each locality, and local unit of government has been given the ability to attempt to regulate or not at all. And so there's going to be some places like Wallace, for example, where it sounds like you might just be able to set up shop as long as you can get a state license. If you go to Sioux Falls, you might have to pay $100,000 for a license. So it's really just going to depend. And so here, we're talking about the area that's in the county's jurisdiction that may be a cheaper license fee than what the city's going to approve. But not that it could concern you, but I'm just saying that's inevitably what's going to be taking place over the coming months here. So.
And the chair would also like to clarify something as well from what Councilman Danforth asked. The council will be taking up action very soon on Ordinance 21-35, which is our part of the joint ordinance with the county. And in everything that we have power over, that is the council, everything is complementary, which means it does not contradict anything else that we can vote over. What the county gets to vote over, they make up their own minds. I think that they recognize the wisdom of this body up here and will follow suit, but we will see. But no, we have our own rules. We'll dispense with those, starting with Ordinance 21-35 very soon as questions and comments are over. With that said, any further questions or comments? Seeing none, the motion is to approve the City of Watertown Ordinance number 21-35. All those in favor, please say aye.
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 Any opposed? Motion carries. I will turn the gavel back over to Commissioner Hanton.
All right, thank you. So what's before us, and we have a motion and a second already on ordinance number 76. Is there any other further comments? Hearing none. Call the roll, Cindy, please.
Gable. Aye. Waterman. Johnson. Aye. Van Duzen. Aye. Hanton.
Aye.
That's 5 in favor.
All right, so that motion carries. All right, again, I read the titles of both ordinance number 75 and 77 when I opened the public hearing. So that's covered for both of those ordinances. All right, let's take a motion on ordinance amending the zoning ordinance for the rest of the unincorporated area of the county first. That is ordinance number 75. Do I have a motion and second?
So moved, Johnson.
Motion by Johnson. Second by Gable. All right, do we have any further discussion relating to this ordinance, the unincorporated part of the county? Hearing none, Cindy, would you call the roll, please?
Gable. Aye. Waterman. Aye. Johnson. Aye. Van Duzen. Aye. Hanton.
Aye.
5 in favor.
All right, that motion carries also. Let's move then to, we have one more ordinance, and that is a motion on ordinance number 77, the cannabis licensing ordinance for the unincorporated areas of the county. Can I get a motion and a second on that? Motion by Van Duzen, second by Waterman. Do we have any further discussion? I don't know, do we need to clarify the hours for sure? Is this the time we could do that?
Yes, that's it, if you had a question on that.
Yep, there was a question, so we are going to just clarify the hours of operation in our licensing ordinance, and the hours of operation are 8 a.m. to 9 p.m. on any day of the week. So, with that, we ready to vote? Let's call the roll, Cindy.
Gable. Aye. Waterman. Aye. Johnson. Aye. Van Duzen. Aye. Hanton.
Aye. That motion carries as well. All right. So at this point, I guess I would adjourn our meeting. So look, motion by Johnson, second by Gable. All in favor, say aye. Aye. Opposed? We are adjourned.
Thank you very
City.
much, Commission. It's always a
Yes.
pleasure to meet with all of you.
Thank you for letting us meet jointly with you.
All right, the chair will reconvene the meeting. This is still the combined meeting, technically, of the City Council and the Coddington County Commission. The commission has left and the city still has some business to attend to. Starting with the agenda item E, the second reading of City Ordinance 21-34, an ordinance adding Title 25 to the revised ordinances of the City of Watertown pertaining to medical cannabis regulations and uses within the City of Watertown, South Dakota. So, the mayor will open public testimony, and I believe we will go to City Attorney Roby for comments.
Thank you, Mayor. I'm gonna pull up, try to pull up that slideshow again.
The chair will make a comment while our city attorney is calling up the information that he needs. Just to remind the council, we have thoroughly vetted this topic at our work session. I don't want to stifle debate, but as far as examining it, asking a lot of the questions, I believe we have addressed a lot of them already. But we still have business to attend to, and that's actually the passage or non-passage of this ordinance and some amendments under consideration. So I would urge the council to attend to business and keep comments pertaining to the actual motions at hand once they're there. City Attorney, please take it away.
Thank you, Mayor. So I have a brief slideshow just to, this is basically the same slideshow that I had presented at the work session, just to kind of where we started from and where we're at with the second reading here today. Just as a refresher, Initiated Measure 26 was approved last November by the voters of South Dakota. Statewide, 70% voted in favor, and Connington County was roughly the same with 69% voted in favor. Initiated Measure 26 was simply the medical marijuana scheme that was enacted. Amendment A was also approved. Amendment A is currently being reviewed by the Supreme Court, but Amendment A, if it's upheld, would also implement adult use or recreational cannabis in South Dakota as well. So we're still waiting on that Supreme Court opinion, not sure when that's going to happen. The other issue that we're looking at as far as an uncertainty is the legislature may or may not decide to make some minor or major changes to Initiated Measure 26 either this November or in the legislative session to come. So the bottom line is, you know, we're making do with what we know today, but there are many unknowns as we go forward in this this new era of legalized cannabis. So under IM 26, it's largely a scheme that is meant for the Department of Health in the state of South Dakota to regulate medical cannabis establishments. But it leaves to cities or local governments a few areas where they are allowed to regulate. One, it allows cities to regulate the time, place, manner, and number of medical cannabis establishments. There's a provision in the law that, with that said, states that dispensaries themselves cannot be altogether prohibited. So read together, that's been interpreted to mean that the number of testing, cultivation, and manufacturing facilities could, in theory, be set at 0, while the number of dispensaries could not, according to the common reading of the law, could not be set at 0. And finally, cities are allowed to come up with a licensing program, a permit program, a registration program, and charge a reasonable fee. So IM 26 provides for 4 types of medical cannabis establishments. It provides for medical cannabis product manufacturing facilities, medical cannabis testing facilities, medical cannabis cultivation facilities, and medical cannabis dispensaries. Under the ordinance you have in front of you today, which has already been approved at a first, or not approved, but read at a first reading and discussed at the work session last week, the proposal for medical cannabis product manufacturing facilities includes the zoning districts of I-1 and I-2. Setbacks would be 1,000 feet from residential districts and 1,000 feet from public or private schools. And the proposed limit on the number of medical cannabis product manufacturing facilities would be no limit. Medical cannabis testing facilities are proposed to be zoned I-1 and I-2 with additional setbacks as 300 feet from residential districts and 1,000 feet from existing public or private schools. The limit again on medical cannabis testing facilities is no limit. Medical cannabis cultivation facilities, again, I-1 and I-2, 500 feet from residential districts, 1,000 feet again from existing public or private schools, and no limit on the number of those facilities. A note on the 1,000 feet. The 1,000 feet is actually mandated by the law, and so the 1,000 feet from public or private schools, is required for all 4 types of establishments. The additional setbacks that we are proposing, that are proposed in the ordinance, I should say, were of our own design. And finally, medical cannabis dispensaries. The proposed zoning districts are the commercial districts, so C1, C2, and C3. The setbacks, the proposed setbacks under the ordinance would be 500 feet from residential districts, 1,000 feet from public or private schools, 300 feet from public parks, the pool, recreational facilities, and the library, 500 feet from daycares. Those would be commercial daycares, is that correct, Todd? Yep. Licensed commercial daycares, correct. So that would not include in-home daycares. And 300 feet from religious institutions. Then the proposed limit under the ordinance is 3. And then we have some additional slides with some information on kind of related to the discussion regarding lot sizes in the industrial zones. And I'll just maybe just pause here and let the discussion kind of start from there, and then we can get into the setback discussion and the zoning discussion if Councilman Bueller had some additional questions on that.
Thank you. We will open it up for public testimony. Are there any written or oral comments? Would anyone like to testify on this? This is just on the second reading of City Ordinance number 21-34, an ordinance adding Title 25. So basically adding the rules of establishing the production, the sale, the dispensary of medical cannabis. Just please say your name and who you're representing, if anybody.
You bet. Mike Lawrence, representing myself. I'm a businessman here in Watertown. I appreciate you guys taking the time. I sat through most of the work session, and then the boat had a little bit of a emergency, so I had to scoot out quick. But just kind of wanted to get into why I think it should be a free market thing. I've been investing in these companies online for quite some time, medical cannabis and then recreational. So I've watched a lot of this on a larger scale. And then I've done business on a smaller scale here. One thing to keep in mind is innovation, I think, is one thing you lose when you start controlling how many people can do something. I believe that these companies are usually vertically integrated. So they come in, they do the growing, the production, the testing, and the sale, a lot of them. One thing you do, okay, let's say tomorrow we open this up, we get 3 licenses. Somebody comes in with a new product that is medically advanced compared to the product that we have in our current marketplace. But there's no way for them to enter our market. There's three spots. We haven't grown in sales. We haven't grown in size of the community. How do we go back to the other three and say, well, we're going to let this guy in because he has a better product than you? We're controlling that, and that's what happens a lot of times when you control business like that. I think the transfer of ownership percentage. Yeah, you can't sell a license, but every year you can do 25%. Well, there's ways, and people will do this. We've learned this with the liquor licenses. If there's a loophole, they will find it. They will exploit it. So we're just creating a system that somebody has to figure out how to exploit correctly. I understand that the fee, it needs to be high enough to protect the people at the police department. The other thing is, you heard the county. We can have one of these things out by the Red Rooster for $5,000. They can walk out there. They can open a business. They don't have a $25,000 to $30,000 licensing fee. Now we're encouraging these people to get in their car and drive out there to get their product. Dan brought up the other day that, if there's only 3, does that give them any less chance of not being able to get their medicine? No, but if this was a pharmaceutical drug, which as a voter, 69% of the people wanted medical marijuana, we're not limiting pharmacies. If Merck wanted to come in here and open a pharmaceutical company here that was going to add jobs to our community, we'd be offering them a TIF. The fact that it's medical marijuana versus oxycodone, that's the difference there. I mean, and one's worse than the other. I don't know. That's for you to decide. But if there was a $70 million pharmaceutical company that wanted to open something here, we'd be welcoming them with open arms. So I think you have to look at some of those issues, and some of those things I think should come into play when you're trying to limit the amount of medical cannabis or businesses, for that matter, that come into this community. Just want to check and make sure I didn't leave anything out. Planning and zoning. I mean, we have the Plan Commission. I've numerous times heard you guys say these people are important. They made this decision. They came up with it. They took the time. They took the energy to go through this. I think that we do have to look at what they came up with too. Otherwise, that board doesn't hold a lot of water. I appreciate what they do. I sat on that thing for 2 years. I know Mike sat on it. I know Bruce sat on it. I know a lot of you guys sat on it. So I do take to what they say to heart as well. The other thing is the black market. There's going to be a black market for this. There's a black market now. If we outprice the current market or limit the amount that people can get, they're going to go to the other black market. And now that we have legalized medical marijuana, I believe enforcement on marijuana altogether is going to be harder for the police department. I think we'd much rather have those people be accounted for and have know what's going on with them, rather than pushing them to a market to try to buy something. I mean, because if they buy it from Joe Schmo on the corner and they have a medical card, how does the police department know that they bought that from Joe Schmo when they pull them over or give them a ticket? So I'd rather have that come from somewhere where we know it's tested, it's safer, than some Joe Schmo on the corner that might have it laced with fentanyl. So, I mean, those are just some of the things that I want you guys to take into consideration. I know you guys have thought about this a lot. I've heard Mike's questions. They're good questions. Just my thoughts on the thing.
Thank you. Is there any further testimony? Any further testimony? Seeing none, the chair will close the public hearing portion of this agenda item. In order for the council to take up consideration, we need an actual motion. But before we take up a motion, I would like to, with the city attorney's back or support, run through 3 amendments that we considered at length at the work session. Amendment 1, in summary, Amendment 1 increases the license fee to $25,000 for both the initial license and renewals. Amendment 2 increases the licensure fee to $25,000 for initial licensure only. And Amendment 3 removes the limit on the number of medical cannabis dispensaries. So the chair will entertain a motion if whoever wants to make the motion wants to add an amendment. Correct me if I'm wrong, Attorney Roby, but they can make the motion with one of the amendments considered, because I consider it that we have already vetted these out at length in the work session.
I would agree with that.
Okay, thank you much. So with that said, the chair will allow some leeway to ask a clarification
Thank you,
question.
Mayor. Just want to clarify, these are going to be substantive, assuming that we make amendments, these are going to be substantive amendments, which means this will need to come back to us for another second reading at a later date. Is that correct?
That's correct. If one of these changes are made, I would interpret them to be substantive changes that would require a second reading.
Okay, thank you. Thank you.
And also for clarification, Attorney Roby or City Manager Mack, I think that you were going to say, we do have time to take up the second reading and get them done before the deadline.
We do. The question I was going to ask is if the second reading would require a public hearing.
So if any of the proposed changes that were discussed at the work session were adopted, they would not relate to the zoning portion of what we're considering. They would either be licensing they would both be licensing, either increasing the number of licenses or changing the license fee. And so this public hearing would suffice for the zoning related purposes of the ordinance.
Thank you. The chair would also make, do you have a point of clarification?
I do, Mayor. On the amendments that were handed out, they talk about the reimbursement at $23,500. That's $1,500, and we had talked $2,500.
Attorney Roby?
That was a typo.
Okay, so we will treat that.
Yes.
Thank you for catching that. So in on Amendment 2, Section B1, Line 1, the city will reimburse $22,500. That's how it will read if someone makes a motion with that amendment. Okay? So we don't need to correct that. With this said, the council needs to actually take up the motion before we can consider it. That does not mean if you make the motion or second it, it does not mean that you support it or have to vote for it. This is just to open up the debate and frame the debate with or without the amendments. Councilman Paulson.
I was just going to make a motion.
And what is your motion?
I will make a motion to approve it with Amendment 1, increasing the license fee to $25,000 for both the initial license and renewal, and Amendment 3, removing the limit on the number of medical dispensaries.
A motion is made to approve Ordinance 21-34 with Amendments 1 and 3, made by Councilman Paulson, seconded by Councilman Bueller. With that said, we have a motion, and we'll now open it up for council deliberation, council questions. Councilman Paulson, since you made the motion, it is appropriate for you to make the opening remarks.
Thank you, Mayor. I think my remarks during the work session still hold true. I believe in free market. I've done a lot of research on this. I do feel that going no limit is appropriate, taking into account the Plan Commission response, and listening to the public testimony confirms that thought for me. But I've also confirmed with the City of Sioux Falls, which their meeting is also tonight, that they are voting on, so it's not official until they do vote on it, but they're looking at a $50,000 initial fee, $25,000 renewal, and I confirmed that today. They will have a limit, however. There are a few communities without limits, and like I said, I've just done a lot of research. I feel like I feel comfortable moving forward with these amendments.
Thank you. Councilman Tupper?
Back to Councilman Paulson, when you said Sioux Falls will have a limit, did they say what that limit would be?
5.
Okay, I got another comment to that if I could. I did a little due diligence last week and contacted 8 doctors in Watertown. For one thing, the state has not did a very good job of informing the doctors and who can even write a prescription or what the reasoning is going to be or what illnesses or whatever. But with all 8 of these individuals, there's not a single one of them that said they would write a prescription other than for two of them. And one is a hospice director at the hospital. Said he would write it for end-of-life situation, or possibly a young child that suffers from seizures. 8 doctors in town all just said the same thing. So we're looking at open it up to the public, and just having an unlimited supply of licenses just doesn't make any sense if there is no real reason to have it. I mean, the doctors are the ones that are going to write the prescriptions, and I know there's going to be some black market doctors out there you're going to be able to call, and unfortunately the state of South Dakota is going to allow out-of-state licenses. I think that was a mistake, but and another thing we got to keep in mind, the only thing that we're working on tonight is initiated measure 26, which is medical marijuana, not recreational marijuana. So I would oppose no limit on licenses. So.
Any further comments? Councilman Danforth.
I just want to go back to it. Mayor, in every case on here, in which case it would be Collins also, it's that 23.5, that withholding of 2,500 is noted in every case in here. So, Colin, I'm assuming, well, I shouldn't assume.
Yes, that's correct. The 2,500 would be members, yes.
I just wanted to make sure that you understood, Mayor, that's through all of those.
Yes, thank you. And we will note that. I mean, just make it official now that if you see the reimbursement of 23,500, it is actually 22,500. Any further comments before, would anyone like to speak before Councilman Paulson speaks again? Councilman Bueller.
Thank you, Mayor. I would just like to say I would support Amendment 3. I do agree with some of the points that Colin has made. One of the big concerns that I have is how are we going, what's the selection process look like? If we're drawing out of a hat and we've got 4 people, 5 people that want to do this, there could be a substantial investment in one of these facilities, and then to find out at the end of the day that their name didn't get drawn and it's going to cost them $2,500. That being the case, my thought is that if we go along with Amendment 3, that would give us an opportunity to vet this a little bit further. That's my concern with this right now. The biggest concern I have is how we select those 3. So I just want that to be known. Thank you.
Thank you. Any further comments? Councilman Danforth, since you just asked a point of clarification, you did not actually speak the first time, so if you want to speak now, you may.
Thank you, Mayor. My thinking on this is to support the restriction to the 3. I mean, personally, we could go 4. I don't care. I think going unlimited, in my opinion, to start off with, I think it would be problematic. If we found out, a year down the road that things have went well, they went to where we have an understanding of how they're going to operate, how well they're operating, I don't have any problem opening that up. But if we let all the cows out first, it's hard to get them back in. And that's where my concern is let's walk here first. Let's make sure that we understand what the impact is going to be to us. Understand our costs and the risks to the public. That's part of our responsibility, is risk to the public. Bruce, I honestly believe, because that's the one question I do have, is within our amendment, are we going to be defining the method of selection? Because that really only pertains to this first time round. After that, it's first come, first serve. Should the method of selection be a part, or is that a whole separate issue?
I will take that as a question to our city attorney.
Thank you, Mayor. Some communities are choosing to, I guess I would say, the communities that are choosing to limit the number, which I believe most that are considering regulating it at all are picking a number to cap it. A lot of the communities are keeping that selection process in-house. And so, for example, I just anecdotally, I know Brandon they have a process where they're going to take sealed proposals, and then they're going to draw out of a hat, and they're going to open up the proposals one by one, and if the one that's drawn first meets all the requirements, they get a license. If not, it goes down the line. But I think they set their cap at 10 or something like that. So what we're doing here, so what the state has done in their proposed rules is essentially offered us a way to outsource that process. So we can pick a number, and if we don't have a selection process locally, the state will have a selection process. So they'll ask us, and they'll say, okay, we've received 6 applications for the city of Watertown. Do you have a limit? And if the council approves a limit, we would say, yes, the limit is X. And they would say, okay, so then they'll go through this process, and assuming all else being equal, and they get to the end and they're all tied, they'll have a random drawing. And the whatever the number is, that's the number of names they'll draw out of a hat, and those folks will get the license.
I think just for some more information, I will call upon our Public Works Director, Heath Von Eye, who has some information regarding other communities and the number of dispensaries.
Yes, thank you, Mayor. And I'll give credit to Stacy for this, our Community Development Manager. She spent a good part of today looking at some follow-up to the zoning questions and also the limitations that other communities have placed on dispensaries. This is a list, none of these in South Dakota, but several in Colorado and then some in Oklahoma as well, as far as the limits they've placed on the number of medical dispensaries. Also calculated here in the right-hand column are the average number of dispensaries per capita. And just wanted to share this for informational purposes. We also have, again, some zoning data. If the discussion leads into that, we can touch on those slides as well.
Thank you very much. City Attorney Roby?
Can I, Stacy, just a quick question of Stacy?
Please do.
What, just if you know, those numbers, were those naturally occurring, like the market created those, or those were created by their ordinance?
I think that it's a combination. As you can see at the bottom of the slide, you'll see Ardmore, Oklahoma and Durant, Oklahoma, and I believe they do not have limitations, and they are a medical-only state, I understand. And you can see that they have very high per capita numbers, whereas some of the other ones, Fort Collins does have some strict limitations there, and you can see that there's is a bit more conservative. So I think it's just a variation of both.
For those watching on television or online or in the audience, that is Stacy Bungard, our Community Development Manager, and she has put a lot of work in on this ordinance. Any further, Councilman Vilhauer?
Have really, excuse me, have really struggled with this. Being a business person, I understand the importance of letting the free market system work. But I also share some of the same concerns that Councilman Danforth has, that we open it up from the get-go, we'll never be able to pull the reins back on this. If we start a little bit slower, we can always loosen that. I had a conversation last week. At our meeting, at our work session, we heard from our Chief of Police, Toomey, about social costs potentially. You were very diplomatic, Chief, if I'm reading you correctly, as far as taking a stance, as far as what you feel, as far as limitations. But I had a conversation last Thursday with a captain of the Rapid City Police Department. We happen to serve on the same board together, and just asked him what they were doing. And there was no bones about it from his perspective. They are very concerned about it when as it's going into effect out in their area. And I said, okay, what are you doing as far as limiting dispensaries? He says the council out there is going with 1 per 5,000 residents, which would equate to, he said, 15 dispensaries out there at this point. But again, he was very concerned about what this is going to mean to their community out there. 3, to me, maybe a little bit restrictive. I am not in favor of going unlimited on this. I would like to propose a substitute motion. Can I do that at this point?
Yes, you may. In fact, I was going to say that if someone did not like a portion of the actual motion that was made, a substitute motion is going to be required for this.
I would make the substitute motion as far as number 3, to change that to 6 dispensaries would be my motion to amend.
So just to clarify, the motion would be to change Amendment 3, which is removing the cap, and instead basically limiting the number of dispensaries to 6. Is that correct, Councilman Vilhauer?
Correct, Mayor.
With that said, I do need a second for the substitute motion. Is there a second on the substitute motion?
I'll second it.
It was moved by Councilman Vilhauer, seconded by Councilman Paulson. Is this debatable? Substitute motion, I believe it is. So,
Yep.
Right now we are only going to discuss the substitute motion before we vote on it. That is basically, it is the number of 6 dispensaries. That is the only topic we are talking about right now. Are there any comments? Councilman Vilhauer, you made the motion.
No, I have no additional comment to make at this point.
Councilman Danforth?
I don't think I got my question answered before, because I think that might weigh in on someone's decision, and that is, are we going to define the method of selection? I personally don't like the state doing it. I'd just soon do it ourselves. I think what you stated that Brandon's doing is a fair way of doing it. You know, we can set the rules here. You know, if somebody qualifies and they have submitted, we can say we're going to give their money back if we want to, so that there isn't that damage. If somebody submits and they don't qualify, well, then they should have probably known that ahead of time. But I still haven't gotten that question answered as to, does the method of selection go into our ordinance, or is that a whole separate issue?
Mayor.
City Attorney Roby, would you like to address that?
I guess, sorry, I didn't directly answer it, but it could. What we've proposed, it does not include a method of selection, because the state has a method of selection that they would perform on behalf of the city, or not, they would perform if we have a cap. If we wanted a different method of selection, it would require us to add that into our ordinance, which would probably push us out some time now, because we don't have that proposed at this point. We could probably copy it from some other cities, but the thought being is that if you defer to the state on that type of an issue, they have deeper pockets to handle potential challenges if there were some challenges to the process. So if we wanted to go back, I mean, that would, in my mind, that would require a pretty substantial addition to our ordinance. So, and I don't know if we have the time to do that at this point, but.
Councilman Tupper?
I got one quick question for City Attorney Roby. Do they have to pass the state's regulations first before it comes back to the city?
Mayor? It comes, the process, somebody would come to the city first, because the state is not going to approve a license until they know that the city has done all of their due diligence. So they'll come to the city first, they'll identify the location where they intend to operate. We'll certify that that location meets the zoning requirements. We'll collect their fee, we'll issue them a license and a permit. Basically, I guess I kind of envision it being almost a contingent building permit, because the state's going to want to know that they're ready to go if the state says go. And so once that's all been done, they'll go to the state and they'll say, okay, the city has checked off all the boxes, now I'd like to apply for a permit with the state. And the state has a more in-depth process. They're going to do a thorough background check of all the owners and board members and significant employees of the company. They're going to ensure that the business plan makes sense. They're actually going to make the applicants identify their suppliers, identify how they're going to price products. They're going to do a thorough check of their business plan, which we're not doing locally. And then assuming that they meet the requirements of the state, then they'll issue a state permit, unless there's a cap on the number. If there's a cap on the number, then they'll go through the process I described earlier.
Thank you. Councilman Paulson?
Thank you, Mayor. Obviously, I'm not for restricting, because I think if we limit this, you're diluting any sample or any license if we do move forward in the future expanding it. You're diluting that market more than if we just started with unlimited, and I think that you're going to potentially cause legal issues because those three people started a business under the premise that I have this license, this is my market now. And I think if we open it up, I think you're asking for a lot of trouble. I also don't agree with restricting liquor licenses, and unfortunately we don't control that. I think our zoning that we're also doing tonight restricts it naturally. I think that there's only certain locations you can put a store. You can only put dispensaries, and all other of all four uses can only go in certain areas. So we're already restricting it to those areas, which I think is appropriate. But restricting the number, I think, gets really complicated. And, you know, a random draw to me is asking also for trouble, because I don't think that's fair to the investors, because they're going to make a substantial investment prior to that random draw. And you're putting all that investment money at jeopardy for whoever does it. So if we're talking about constantly protecting the people of this community, I don't get why one is protecting them and one's not, because it's not. We're not here as stewards of someone else's money. We're here to protect the interest of our community, and I don't think that I'm just strongly against this. I could ramble on, but it doesn't make sense to me why we would restrict business. And going to the doctor's points, that's 8 doctors. What if one does? What if we need one doctor in this community to write licenses? I don't care if there's 100 of them, because there's always going to be a black market, like you said. So people are going to get a license. Period.
Councilman Tupper?
Just a question for Councilman Paulson here. When you just made the comment that these people are going to invest a lot of money into an establishment and might not get a license, I think most strong business people are going to have something contingent upon a location that they receive a license before they go investing a lot of money.
Councilman Paulson, would you like to answer that?
I don't disagree. I think that would be the smart business plan, but I think at the same time, you have to have everything lined up, ready to go if you're going to submit a license, because they have to meet our qualifications, so they have to meet all the zoning requirements before they go to the state. So they have to have everything in line, and they're gonna start sourcing. They're gonna start buying equipment. I mean, all of that has to happen before you're even talking about getting a license, because if you're not at that point, you can't meet zoning requirements. And not everything can be contingent upon a license. So that's why I think that there's going to be a lot of investment that's going to go down the drain if we start doing restrictions and random draws.
Thank you. Any follow-up, Councilman Tupper?
It's no different than buying a bar or building a bar. If you're going to stick a bunch of money into a bar before you don't have a license, that's not a good business plan. And I got to go back to one thing that really originally set our limit at 3. And that's those gentlemen sitting back there in blue. That's what they feel they can comfortably handle in the city of Watertown. Now, 6 months down the road, if they've comfortably handled that and they think they can handle 6, I see no reason to not going to 6. But do we want to put disrespect into their job to try to handle the city streets of Watertown, to keep it being a great place to raise a family, work, grow, or do we want to just let private enterprise run that? And how many people we're going to put out on the streets selling marijuana?
Thank you. Any further? Councilman Danforth. Now, we are still only on the substitute motion of the number, limiting the number to 6. That's the only thing we're discussing.
I'm going to ask for some clarification, because it does probably indirectly relate to that. if I am going to submit an application, I just have to have a plan that identifies a location. I don't have to have the equipment in place. I don't have to have the building secured. I don't have to have sources of supply at that point as far as, because that's going to change over time anyway. Those things, this is my understanding, is those things don't need to occur. You just have to have a business plan that says, here's where I'm going to be. It has to be an acceptable place, and that they would meet the requirements within the ordinances, whatever those all are. You don't have to have them in place. Is that correct?
Yes, that's correct. So, it could take, to take that a little further, if you identified a location that you didn't do your due diligence to either secure by an option or a lease, a contingent lease or something like that, and then you didn't have that location available, your license is essentially void by our rules and the state's rules. You're going to be licensed to operate at the location you indicate, and if you for some reason aren't able to secure that location after you've indicated you're going to operate there, that's going to be your own fault.
Right. But my point is that really the amount of the expense for the most part is time in preparing a business plan that identifies these things of how you're going to achieve compliance. Is that a fair and true statement? And there's got to be obviously some assurances in there that I'm going to know that I can get that building, that location.
I would agree with that. I would also put a plug in for the local private attorneys, because there's 124 pages of state rules that I'm not going to walk every applicant through. So everybody that's interested should go find a private lawyer.
But I mean, there's going to be some cost, but it's not like it's going to be an exorbitant amount of money. I mean, if the other thing is, and I do want to, if we later do increase this number, let's say we're at 3 today, go to 6, or we go to unlimited later, I'm not sure how that dilutes the first 3 or 6 dispensaries licensing, because the fees are set. It's not a free market on what those fees are, that cost of that license is. We're setting that number. So I'm not sure how that would dilute that as a risk in making that difficult down the road. Comments? Yep.
Councilman Schutte.
In observing the discussion from last week's work session to tonight's discussion, it is obvious there's unknowns. There's challenges we're working through. And with the number of dispensaries that we're talking on that motion right currently, the number 6 would put it at roughly at 1 for every 3 to 4,000 people in the city of Watertown. One of the things that Congressman Danforth had mentioned in last week's work session was walk before you run. And just wondering if 6 even is really walking before you run, being that's 1 for every 3 or 4,000, which I guess in my opinion that's kind of moving a little bit more forward, headstrong in it. And I mentioned last week too about just having a foundation we can start with and build on. And so that's where I still believe that even per discussion, good discussion tonight, having that foundation of 3 can be something to build on with, absolutely. To evaluate this as we learn and as we go in this. So just my comments on this.
Thank you very much. Any further comments upon the substitute motion to limit it to basically change Amendment 3 to 6 dispensaries?
Mayor, can I add one thing? This came up earlier in conversation, and Amanda asked me to point out this scenario that we'll have to think through with a cap. And so, for example, if we do have a cap and 2 years down the road, so let's say there's 6 applicants and we set the cap at 3, just for hypotheticals. 2 years down the road, one of the 3 decides they want to sell their business to somebody, and there is a mechanism under the state rules that would allow them to come in and apply for have that new owner apply for a license. Is it fair that new owner should now get that third license instead of the person who was in fourth place on the random drawing 2 years before. And so if there ends up being a cap, we'll have to think through that down the road. And I think that that's maybe a good segue into the fact that because of all the potential changes that are coming forward, we're likely going to have to revisit this ordinance 2 to 3 times and make changes in response to the legislative changes over the next year or two. So,
Councilman Paulson.
Thank you, Mayor. I guess Attorney Roby's comments just kind of reinforced my thought is now we're getting into picking and choosing how we're controlling who gets a license. Is it going to be this way or that way? Is it going to be because you were fourth on the list or because we did a redraw? And I disagree strongly with that.
Thank you very much. Any further comments upon the substitute motion? Seeing none, the chair would like to make a comment for the public and everyone in the room. As you can tell from the conversation up here tonight and the questions, there are still a lot of unknowns. And crafting laws can be very tricky because we're basically making rules that apply to everyone. And not everyone gets it right the first time. And I don't think that the state or the city is going to get it all completely right the first time because there's still a lot of moving parts. We don't know. We're just doing the best that we can. If someone does not vote the way that you would like them to vote, it's probably not indicative of what you think. So don't read anything more into that than other than we are trying to craft the best laws that we can under the information and situation that we are living in. So with that said, the chair will call a roll call vote on the substitute motion to, this is the substitute, to basically substitute the original motion, which is taking out Amendment 3 and capping the number of dispensaries to 6. With that, Financial Officer Kristen Bobzien, call the roll.
Okay. Bueller.
No.
Danforth.
No.
Pauline.
No.
Paulson.
No.
Shetty.
No.
Tupper.
No.
Billhauer.
Yes.
That motion fails.
Motion fails. We are back to discussion upon the original motion, which was passage of City Ordinance 21-34 with Amendments 1 and 3. Any further conversation on that? Just keep in mind, if someone would like to cap the number of dispensaries at 3, which was the original, you would also have to make a substitute motion at this time.
I would make that motion.
Councilman Tupper would make that motion to strike out a substitute motion.
Make a suggestion.
Yes.
I think it would be simpler if you voted on the motion that's on the floor, and if this motion fails, that you entertain a new motion
Okay.
with a limit. I think we're going to get way down in the weeds on amendments.
Yes. So actually,
So the motion on the floor is
a passage of Ordinance
Unlimited.
21-34 with Amendment 1, which
And
is
three.
$25,000 for the initial and renewals, and no limit on dispensaries. That's the original motion. And actually, that's probably a good idea, because if this passes, then we're done with that for tonight. But if you want the number of dispensaries capped, you need to vote against this motion. And then we will make a substitute motion, just to make it very clear to everyone. If you want, there's been no comments upon Amendment 1, so I think that's probably good. So the issue up to debate is the unlimited versus 3 dispensaries. Right now we are voting on unlimited dispensaries. And
a $25,000
And a $25,000, yes.
fee and $25,000 renewal fee.
Yes. So with that said, the ordinance, or the motion is for passage of City Ordinance 21-34 with Amendments 1 and 3. Kristen, would you please call the roll?
Okay. Bueller.
Yes.
Danforth. No. Pauline.
Yes.
Paulson.
Yes.
Shetty.
No.
Tupper.
No.
Billhauer.
No. No.
That motion fails.
Motion fails.
The chair will now entertain another motion for, I would suggest, a motion for passage of City Ordinance 21-34 with Amendment 1. Actually, I don't even want to presume, but that would be the motion that I would see, because Amendment 1 did not get much consideration in the initial debate, so I'm guessing the council is roughly in favor of that one. So that would be the motion I would recommend, but I am open to anything that a councilman would like to make. But I do need a motion. Councilman Tupper.
Just to clarify, that's with the limit of 3?
Correct.
With the $25,000?
Yes.
I would make that motion.
So, motion made by Councilman Tupper, seconded by Councilman Danforth. We are under consideration for passage of City Ordinance 21-34 with a $25,000 initial licensure fee and an annual renewal fee set at that price as well, with a cap of 3. That is what we are debating right now. I know that we've already discussed the cap number and what we all believe to that, so unless there's new information regarding the cap, I would say focus upon the actual motion or something else. Councilman Paulson.
Thank you. If we are going to cap this, I disagree with the 25,000. I think that 25,000, based on our discussions, was to help restrict an unlimited number. And I get that we also had our police officers tell us that it was going to cost us more. So I don't think we should go to 5, but I think that if we're already restricting it, I don't think we should go to 25. I would ask for something less, personally.
Councilman Danforth?
We are actually voting on the fee for all 4 uses, correct?
That is correct.
So it's not just 3 dispensaries or 6 or unlimited. It's any number of testing sites, any number of growers, any number of manufacturers. So it's that combined number that my understanding was, and my justification was for supporting that, because we don't know what those numbers are going to be.
Correct.
So that was my understanding as to how we got to the 25, was the aggregate, not just for the dispensaries.
Right. Any further comments upon this motion? Seeing none, up for consideration and vote to the council is passage of City Ordinance number 21-34 with a licensure fee of $25,000 and renewals at $25,000 and a cap on dispensaries at 3. Everyone clear on that? Kristen, would you please call the roll?
Okay. Bueller.
No.
Danforth.
Yes.
Pauline.
Aye.
Paulson.
No.
Shuddy.
Aye.
Tupper.
Yes.
Billhauer.
Yes.
That motion carries.
Motion carries. We'll move on to agenda item F, second reading of City Ordinance number 21-36, a zoning text amendment to Title 21 pertaining to medical cannabis regulations and uses of the revised ordinances of the City of Watertown. Are we going to City Attorney Roby or Community Development Manager for this?
I don't have anything else to add at this time. It's essentially the additional piece that's required here to install those uses into Title 21, unless Stacy has something else to add.
I'd just like to present a few different things. I know that there was a bit of discussion at the work session on the I-1 and the I-2 district, and I did do a bit of research, so I'd ask Director Vonai to bring that up for for you to take a look at. I looked at sites in Denver, Colorado, just because there were a bunch of them that I could find and the data corresponding. Wanted to preface this a little bit. I had no idea going into it what lot sizes would be useful for cultivation facilities. So you can see that there's it ranges from 12,000 square feet up to 286,000 square feet in size. Remember, Denver is quite a bit larger and a lot more dense in terms of basically what you'd find there for development. But basically, an average of 10, the lot size averaged to be 81,000 square feet. So I find that with the question that we had previously from Councilman Bueller, that the I-1 district with our 30,000 square foot lot size limit would work well for the cultivation facilities. The I-2 is a bit large at the 5 acre minimum. And then the next slide, just briefly, for manufacturing, basically 80,000 square foot, 81,000 square foot. I think that we need the next slide, Heath. Okay, 33,000 square feet basically was for the manufacturing facility lot sizes. Again, there's 4 of them, or 5 of them rather, and they range from 15,000 up to 45,000. So again, I think that the I-1 district at our 30,000 square foot minimum does also accommodate these as well. The I-2 district, if somebody wanted to own their own lot, there would be a way to do that through a condominium plat. But currently right now we have that 5 acre minimum in the I-2. So if we want to go to quickly to the testing facilities, these were the smallest ones. And then I looked at 5 of them and they range in size from 6,000 up to 23,000, 16,000 square foot minimum. Still could potentially work okay with the 30,000 square foot minimum that we have in the I-1, but the I-2 at the 5 acres is quite large for a testing facility site. So that actually led me on to something else. I do believe that there's another slide in here. So then I got to thinking, well, gosh, are our minimums a little bit larger than other communities? And so what I found was definitely they are larger than other communities. So just wanted to show you guys this, council members this evening, just for comparison's sake, that our 5 acre minimum is very, very large in terms of what's out there. The largest I found within our state is a 1 acre minimum for a lot size. So having said all of that stuff, I believe that that's something we can look at if the Plan Commission and the council feels that we should take a look at that, our lot sizes for the I-2 district in particular, based on this research. Thank you.
Thank you. Any further testimony? Any further testimony from the public? Or seeing none, we'll close the public hearing section of this, and the chair will entertain a motion. Motion is to approve City Ordinance number 21-36, made by Councilman Danforth, seconded by Councilman Schutte. Any comments on that, Councilman Danforth? Any further comments upon this? Seeing none, the motion is to approve City Ordinance number 21-36. Kristen, would you actually, all those in favor, please say aye.
Aye.
Any opposed? Motion carries. With that, the chair will call to a close the joint meeting of the City Council of Watertown and the Coddington County Commissioners. And the chair will now move on to the official action of the City Council for tonight. As we have already established a quorum, or do we have to reestablish one? Or do we, now is the time to, chair will call a 5-minute recess while we end the video feed on the joint meeting and, oh, sorry. Okay, so we do actually need to adjourn from the combined meeting. So motion to adjourn, made by Councilman Tupper, seconded by Councilman Paulson. All those in favor, please say aye. Motion carries. Or nay. 5-minute recess while we end the video feed and start up for City Council.